in the city's oceanfront resort area, which is now an active crime scene.
It's an active crime scene. Look at that hotel. You know what this looks like?
Virginia Beach.
Not Virginia Beach.
Galveston.
I went to Galveston. I drove to Galveston, actually. At the time, I actually had glasses. I drove. It's right after I got my driver's license. But it was after I'd gone to Houston and picked up my birth certificate because I had to leave. I went to Austin, then I went to Dallas, then I went to Fort Worth. Yesterday, they discussed how they had to shut down the VA center in Fort Worth. Why? Storm damage. Which storm? Hurricane Laura? Is there too much fucking child porn going through the VA center in Fort Worth right fucking now? Because you're doing illegal transfers of stock that are supposed to be connected to military assets, but you're laundering it through muni bonds, including muni bonds that would be used to finance public schools. That officer is expected to be okay. And you had to actually shed blood again on Virginia, because Virginia is for lovers. That's what you fucking did last night. And the date of the major stock issue they did, the bump stock. They did a bump stock issue on May 11th of 2020. And you know damn well the reason nobody will acknowledge what I did in Chicago before you kidnapped me in San Francisco is because you literally used the articles I wrote while I was a newspaper editor for underwriting on, among other things, what is now Trump Tower. And here's the question. Who is getting the leverage? Is it actually Trump and the Trump supporters based upon having that major fixed asset? Or is it all those people that are trafficking other people because somehow they think they're proving something to Trump and the Trump organization by fucking around with people like me and using little kids to do it? See, nobody will admit what they actually did. Nobody's been admitted, including the fucking Department of Justice, including the FBI, including police departments in 6 cities, including unions associated with municipal workers, with public school teachers. Nobody in federal office, nobody in at least 3 state governments, up to and including the attorneys general, will admit what they actually did. I mean, I'm just one woman. I'm just one woman that has been trafficked since before she was 10 years fucking old for a bunch of people that were actually allowed to be in government. Does anybody else maybe have something to say on this? Hold on a second. Hold on just a second. Okay, I'm going to start the opposite of where I want to start. Why? I don't know. Can I undo another shooting? Can I undo the second terrorist attack in the less than 14 days so far? That would have been the appeal period, including the one that I think I'm supposed to acknowledge as an order from my command officer via some magistrate judge process that's completely inappropriate anyway and doesn't expire until the day that a bunch of really, really horrible retaliatory tariffs end up coming in. I mean, it's going to be really, really hard to take in rem from somebody this completely fucking incompetent in a command position. It really is, especially when, if I don't let her hijack my fucking vessel, then what happens when those tariffs come due on the deadline for the fucking appeal? I'm serious. You let her do all of this horrible, horrible bond fraud for going on 2 years now in conjunction with a bunch of other black robes. And every time it goes this badly. And our policy is so horrendous. I already know what those tariffs are like. And you intend to try to extort me because you're threatening to wave them off on kids again. And whoever your commander was that was supposed to protect the home front, his priorities were too much of his own self-interest and the self-interest of his co-conspirators than to actually apply an appropriate process to secure the actual literal children. I'm not talking about the subsidiaries of your parent companies in your little portfolios. I'm talking about actual children. I'm sorry. Concerned with long-term criminal activity, Congress enacted RICO to prohibit conduct involving a pattern of racketeering activity. Cite See Word of Faith World Outreach Center Church Inc. versus Sawyer. Quote, one of RICO's enforcement mechanisms is a private right of action available to, quote, any person injured in his business or property by reason of a violation of the Act's substantive restrictions. Anza versus Ideal Steel Supply Corporation. Do you know what those retaliatory tariffs connected to the steel sector specifically look like? Do you know what they feel like? Do you know what you can finance if you engage in tax fraud involving retaliatory steel tariffs? Well, the people who applied them knew what the intent was. And the people in this country that refused to actually prosecute criminal activity, including racketeering, that was being conducted by alleged representatives of the people that had extorted their way into public office, they know too. They showed that last fucking night. They showed that last fucking Monday. They showed that on February 9th. Over and over and over again. Key, strategic, completely premeditated moments that should already have been stopped, that should have been stopped over 3 years ago. Well, you decided you wanted to use it as insurance underwriting. We've got 21 murders in less than 14 days. 13 murders. And how many other people? 12 murders and 9 injuries. Right? Because 9 of them aren't dead yet, right? You got a 12 and you got 9 in less than 14 days. What kind of rates are you going to get, guys? What kind of rates are you going to get? It's literally that strategic. Do I have to injury to my business? Private right. That's what you've put it on. What's this case? Well, let's go a little further up and let's see, because this was the actual thing that was important to identify. What did she say? No facts. She didn't plead the facts. Analysis. Federal Rules of Civil Procedure 12b-6 allows dismissal if a plaintiff fails to state a claim upon which relief may be granted. Federal Rules Civil Procedure 12b-6, Bell Atlantic Corp versus Twombly. 550 U.S. 554127, Southern Court 1955, 2007. In considering 12b-6 motions, courts generally must accept the factual allegations contained in the complaint as true. Kaiser Aluminum and Chemical Sales Incorporated versus Avondale Shipyards Incorporated. 677 F2D 1045 1050 5th Circuit 1982. Except in limited circumstances not implicated by this motion, the court does not look beyond the face of the pleadings when determining whether the plaintiff has stated a claim under Rule 12b-6. Spivey versus Robertson 197 F3D 772 774 5th Circuit 1999. Quote, a complaint attacked by a Rule 12b-6 motion to dismiss does not need detailed factual allegations, but a plaintiff's obligation to provide the grounds of his entitlement to relief requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Just so you know, when you say that you've got some special order that you don't even disclose, that is actually in violation not only of the local rules, but also the federal civil rules of procedure, that says that, well, there's no reason to actually adjudicate it. We're just going to put it through a system of automation, and you, bad faith, and no cause of action, and no stated claim. That sounds like a formulaic recitation. A formulaic recitation of the elements of a cause of action will not do. You can't even meet your own standard. Twombly 127. SCT at 164 to 65, citing San Juan versus American Board of Psychiatry and Neurology, Inc., 40 F3D 247-2517 Circuit, 1994. Internal citations omitted. And, quote, factual allegations must be enough to raise a right to relief above the speculative level. Specific in the original request, motion for new trial, was that the previous abuses, including use in derivative actions without acknowledging the stated claims. You know, the facts of the case, including the facts of the case listed in a more than 300-point statement of facts, listed in a several-page explication of the specific, not only implications of pattern of racketeering activity, but the manners in which the pattern of racketeering activity qualified as a certain kind of criminal enterprise that also portended potential application or implication in even more criminal activity that thus far seems to be the focus of whatever else is being attempted for accomplishment rather than actually addressing the stated facts. At 1965, supporting facts must be plausible, enough to raise a reasonable expectation. Quote, the issue is not whether a plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence to support the claim. End quote. Shure versus Rhodes, 416 U.S. 232-236, 94 SCT, 1683, 1974. I asked twice for a secure evidence submissions process, for absolutely no reasonable explication. I was denied anything close to an evidence submissions process, which would have been necessary in order to be able to successfully prosecute a criminal RICO case. Not only that, I wasn't even allowed to talk to a so-called prosecutor. You're using my reports of Social Security fraud to finance strategically coordinated acts of murder in my home state. This is the second time that happened. Remember that shooting at the courthouse? And we're talking this time about transfer of stock connected to a municipal bond portfolio. I'm sorry. This just sounds like what did they say here? I just want to make sure. Sometimes you get a little, off course when you're that. More than labels and conclusions. Is that merely labels and conclusions? I contend that taking a criminal RICO case that is requesting consideration of acts of financing domestic and international terrorism and putting it into automation for case management implies bad faith on the part of those who insisted on putting their name all over major securities that are involved in whatever the other interests are they're trying to pursue by using my case as a derivative action. 3 times in just 2020, the same court in downtown Dallas has strategically coordinated decisions that have been reported on in the public realm, including in the media, that meet the benchmark dates that were set up in concurrence with my case and the other cases that had previously used my case as a derivative action, that have escalated to the level where we've got 12 deaths and 9 injuries just from 2 events in one 14-day period. That is that specific and that literal. What's this case I'm citing? Because some of these cases that I just referenced are also cited in what was supposed to be some sort of sua sponte, I guess. What's this case? Fisher Lane Smith Idle Kevin Smith Idol versus Halliburton. Did you literally just want to ping me as your Santa Cruz so that you could try to get some response that you already intended to hook up as part of your kickback scheme connected to DoD contracts, including ones that are in conjunction with Halliburton contract awards associated with provision of services in, among other places, Iraq? Would that include delivery of repatriated oil from Syria to Iraq that would then be brokered through some derivative action involving what would otherwise be identified as humanitarian assistance, including medical assistance, including potentially mental health assistance for people who are traumatized by war? Would that mental health assistance potentially involve prescription of medication up to and including psychotropics as a way to deal with their trauma? Let me ask you, how many of them might require some kind of pain medication because they've got, I don't know, a chronic injury? You had no right to do this. This is my response. I am not giving you more commercial paper for you to finance acts of terrorism and try to pull some sort of stunt that somehow you're covered because somebody allowed for you to be able to abuse the judicial branch of the government rather than actually providing due process for the people of this country. Because let me tell you, if you're working for China, you're doing a great fucking job. You need to be stopped.